Good morning, members. We have already formed a quorum, so I declare the meeting open. First of all, we have to elect a chairman. Do we have any nominations? Mr. Andrew Leung. I would like to nominate Mr. Ting-kwong. Do you accept the nomination? Any seconder? Yes, Mr. Lee seconds. Mr. Ting-kwong, do you accept the nomination? There are the nominations. Mr. Kai, Mr. Kenneth Leung. Any seconder? Mr. Dennis Kwok. Mr. Leung, do you accept the nomination? Yes, I do. There are the nominations. If not, since there is more than one nomination, and both nominees have accepted the nomination, so we want to proceed to an election. Shall we do so by vote of hands? But then the clerk has already prepared the ballot papers, and they will be handed out to members.
因為黃定光呢係
Mr. Wong has been nominated first, so he will be given the number candidate 1, and Mr. Kenneth Leung will be number 2. The Secretariat staff members are handing out the ballot papers as well as a stamp for each of you. So please use the stamp to indicate your vote. Please stamp it underneath the arrow.
我提一提你哋啊，要掹開咗個 cap 先至吸落去，唔係吸落去。
Please remember to remove the cap. Otherwise, even if you stamp it on the paper, there won't be any ink coming out.
莫乃光議員同埋謝偉俊。
Charles Mock and Paul Chair, we have 2 nominations, Mr. Ting-kwong and Kenneth Leung. We have given out the ballot papers. Mr. Wong is represented by the number 1, and Mr. Kenneth Leung appears as number 2.
OK， 我俾多30秒你哋好嘛
I'll give you another 30 seconds, and at the end of the 30-second period, the voting will come to an end.
OK， 而家投票。
All right, members, voting has ended, and I'll invite the staff members to collect the ballot papers for us.
請頭先呢，有需要呢，頭先係提咗2位候選人嘅議員呢上嚟監票。
好我想請。
I would like to invite the 2 nominators, Mr. Andrew Leung and Mr. Kai, respectively, to come forward to witness the counting of the votes of the ballot papers.
Sì. 14張票。
我哋唔使唱，
唔使唱啦，唔使啊。好，一共咧就有。
Altogether, 14 members voted. Mr. Wong Ting-kwong got 9 votes and Mr. Kenneth Leung 5 votes. I declare that Mr. Wong Ting-kwong has been elected as the chairman. Sorry, the mic isn't really working very well. So I will invite Mr. Wong Ting-kwong to come up to take over the chairmanship.
多謝大家。我要問大家呢，係需唔需要選副主席？好，若果唔使，我哋就係單仲偕議員。
我支持選。
好。大家同唔同意？副主席。
幾生嘢佢問大家意見啊嘛。
What about your views? No comments. All right, Mr. Sin Chung Kai. What suggestions do you have? I propose I nominate Mr. Kenneth Leung. Mr. Chung and seconds. Mr. Leung, do you accept? Yes, I do. Any other nominations? No. Then in this case, Mr. Kenneth Leung has been elected and contested. All right, let's invite the team of public officers to join us. From the administration, with the following officers attending the meeting: Mr. An Sin Yu, Principal Assistant Secretary for Financial Services and the Treasury; Mrs. Karen Ho, Deputy Principal Solicitor; Ms. Felix McKenna, Deputy Principal Solicitor; Mrs. Christine Francis Sid, Senior Solicitor; Ms. Margaret Chen, Solicitor, Department of Justice; We have Mr. Sunny Chen, Senior Assistant Law Draftsman, and Ms. Phyllis Poon, Senior Government Counsel. First of all, I'd like to give the floor to the administration to brief us on the 5 pieces of subsidiary legislation, namely companies, words and expressions in company names order. LN7, companies' disclosure of company name and liability status regulation. LN8, companies' accounting standards prescribed body regulation. LN9, companies' directors report regulation. LN10, and companies' summary financial reports regulation. LN11. So I'll give the floor to the administration to give us a briefing. Thank you, Mr. Chairman. Good morning, members. In August last year, the Companies Bill was gazetted, and it has become part of our laws. As we have briefed the panel, we have prepared 13 pieces of subsidiary legislation, which will form part of the new regime. In January, we have your agreement to submit the subsidiary legislation by batches. So you're dealing with the first batch, and there are 5 pieces of subsidiary legislation. As to the content of the 5 pieces of subsidiary legislation, you find them in the Legislative Council brief, CBT/7/6C. I will brief you on the 5 pieces of subsidiary legislation very generally, and then, subject to your agreement, we'll go into the details later on. First of all, companies, words and expressions in company names order. And this is to deal with the restrictions on the words and expressions used in a company name. Currently, Cap 32E carries a list. And if certain words or expressions are to be used in the name of a company, before a company is to use such a name, the registrar's permission is needed. And the company's words and expressions in company names order seeks to reenact the provisions. And we also remove the duplicative words and expressions. Currently, there are about a dozen of such words or expressions. So when you do set up a company, and if you would like to include such words or expressions, you need to have the prior approval of the company's registry. You'll find the actual words and expressions in the order, which is in Annex A to the electrical brief. So this is the first piece of subsidiary legislation, which is relatively simple. The second one is companies' disclosure of company name and liability status regulation. And we are actually talking about Section 93-94 of the current legislation. And we talk about the need to display and disclose a company's registered name at the company's offices and places in which the business is carried out.
The disclosure of company name and liability status is actually repeating the existing regulation, and because of change of times, we're making some amendments, updating it. And currently, in the Legislative Council brief, paragraph 4, we have listed these amendments for your reference. For example, we allow an electronic means of displaying the company name, and when the business name is displayed in the venue, in the past we required it to be painted, or and we now heard that in the exterior of the venue, when the business name is displayed, there are some difficulties, so we now allow some flexibility. So as long as a visitor can see this name, then it would be sufficient. For example, in the reception area, there's a glass door, and we don't insist that the name has to be painted or fixed to the exterior of the business venue. So we're just making it more flexible. And we also allow electronic displays. Or, for example, some secretarial companies, their offices serve many clients. So to make it convenient for displaying, then we allow them to use an electronic display to display company names. And these electronic displays are regulated in the legislation. And we also have some exemptions. For example, we've taken into account the practice of company service providers and liquidators, and they have no accounting transactions since incorporation, and therefore they don't need a display. So these will be the overall amendments, and we can come back later in more detail. The third is about companies' accounting standards. There are only two pieces of regulations under the new company bill. There is a change. In the past, we had Annex 10 and 11 dealing with the contents of the accounting reports. Under the new companies regulations, we have made a directional change, because in Annex 10 and 11, if their accounting standards are different, then compliance might be somewhat difficult. So we've taken the approach of deleting Schedule 10 and 11, and rather we would have the company to comply with the accounting standards of a designated body. The designated body will be the Hong Kong Institute of Certified Public Accountants. It's a straightforward arrangement. The fourth area is about director's report. Under Section 129, the director's reports have to be disclosed. So under the new company bill, in order to make it easy to update, the regulations relating to director's report are now included. There isn't any significant change. We have added measures to enhance transparency, and this is in paragraphs 9 and 10 in the Electoral Council brief. For example, in the past director reports, they have to have information on equity-linked agreements. So besides equity-linked agreements, there's not exactly share placements, but we now have equity-linked agreements. So we feel this type of agreement will affect the share placement. So similar to share placement, we require them to disclose these agreements. Another example, let's say when there is a director who has resigned or declined to stand for re-election because of disagreement with the board of directors. For these situations, to enhance transparency, we require a simple disclosure of these reasons. But this is a new requirement. So we require these to be applied to larger companies. There are other amendments. For example, the upper limit of donations, it is now amended from $1,000 to $10,000. We also have, we don't have the requirement to disclose debentures. And in Section 470, We restate the new disclosure requirement regarding permitted indemnity provisions of directors. So these are the amendments. And we also have the fifth area, the fifth batch, summary financial reports. Under the company bill, we already have relevant sections dealing with summary financial reports, but currently these are only applicable to listed companies. Under the new companies bill, we have extended it to apply to all companies that don't have summary financial reports, including public non-listed companies and that have not elected to use summary financial reports. So they can now elect to provide financial reports and the summary financial report. So we have the requirement that the company can consult whether they would like to receive a summary financial report. If the directors do not respond, then it is deemed that they will accept a summary financial report. So this regulation, first of all, regarding the consultation of its directors and seeking their response, the relevant forms and information, there are some requirements. Regarding the summary financial report itself, this is described in the requirement for listed companies' summary financial reports. There isn't any big change there. Okay? So members can raise questions. We don't have a lot of questions, so I won't set a time limit. But first, Mr. James Tian. In this batch, there are some questions. The first, the government wants to enhance transparency, and that is very reasonable. But in the display requirements, so first of all, if the company has Chinese and English names, then we require a Chinese and English name displayed. Second, I'd like to ask, in our multi-storied building, the ground floor level have displays, but if you've rented the 18th floor, unit 1801, it's not a large space. And if I have 20 of these companies, as the government said just now, these companies might be shell companies, they don't have transactions, so they might operate on one floor. Is there any difficulty in requiring a display there? Because on any story we might have a lot of companies, so will it be hard to find these displays? The third question, on size, is there any limitation? Does it have to be at least 1 inch by 1 inch or X by Y inches? Because for commercial registration, if it's registered in the company's registrar, you'll be able to find it at a certain building, in a certain unit. But do you now require the building lobby to have all this information, or on the 18th floor on the unit 1801? Could the administration respond?
Respond to that. If there is a registered English and Chinese name, both names must be displayed. If there is only a Chinese name, any English translation of the name must have the words limited in Chinese attached, and vice versa. Just that is to alert people to the status. In relation to the size of the characters, the legislation provides that it must be in legible characters. Legible characters. So there is no actual parameters defined, or there's no size depicted, but it has to be legible, so that will just be reasonably interpreted that it can be read with the naked eye. I think the UK does have a more definitive position. They say it has to be characters that can be read by the naked eye, but we just use legible just to try not to be over-regulating. We have tried to be a little bit more flexible in relation to the nature of the display. So the criterion now is that it can be easily seen by any visitor to the premises. So that is open to more, I think it facilitates the companies in situations that you were trying to say. So, for example, if a visitor to the premises goes to the lobby and the name is displayed there and it's displayed easily for the visitor to see, that will be in compliance with the regulation. There's no need now for it to be actually affixed outside of the office itself. So it does provide for more flexibility. In relation to shelf companies that have had no transactions at all, there is actually an exemption from these companies, so there's no need for that display. So a company secretarial company, which perhaps has hundreds of companies ready to sell, but has not actually, there's no business being done or there's no transactions being carried out, we have introduced an exemption for these companies, which is new. And again, that is based upon the English position, the position in the UK.
A short follow-up. I'd like to clarify the example given just now. So we only need a display in one area. Let's say I have a display in the lobby, that would be sufficient. And it says, or I could have it on the 18th floor or on unit 1801. So I just need a display in one of the three areas. I don't have to have three displays in all three areas. Is that correct?
If there's a secretarial company who are on the 18th floor with lots and lots of companies, I think they would have to display at their office, because it's not going to be possible. The secretarial company name will probably be displayed in the lobby, and that will, the visitor will be easily ascertain where that office is. But when it goes to that office, if the secretarial company has 500 companies registered and 200 live companies, they will then have to display outside that, not outside that office, at that office, the information relating to these companies. And in that connection, we've also introduced the electronic display so that they can actually have options as to how they can do this. And it can be an electronic display, an LED screen, or it can be an electronic device that they have to press a button or something, I presume, and the scrolling will start and the names will come up so that the visitor can see which companies are in fact at that particular address. So it does allow for flexibility.
Okay. How
Ms. Zheng, well, my question is quite similar to that asked by Mr. James Tian. What I think is that when it comes to the regulation, that is disclosure of company name and liability status, I think there's something quite unclear in the Chinese version. It talks about the legible character, and it has to be continuously displayed at the address of the company as well as the places in which its business is carried out. And it should be a place open to the public. And it should be located at a place which is easily seen by the visitors. So you talk about 3 points here. You have to display it inside the company, that is at its registered office. You also mention every business venue of the company. And you also talk about it must be so positioned that it may be easily seen by a visitor. So it gives me the impression that it has to be displayed at a number of places, since the word used here is and rather than or. But according to the answer given to Mr. James Tian's question, it seems that it should be an or instead of an and. Since it is a question about the Chinese version, so allow me to attempt. Yes, Mr. Jiu, if I may clarify the position. Well, every company has got a registered office, and then other than that, there may be other business venues. So the requirement is that at each of such venues, the name must be displayed. That is both the registered office as well as the business venues, so long as they are open to the public. So that's the requirement. As for how you're going to meet the requirement, the condition is that it must be positioned in such a way that it may be easily seen by any visitor. In the past, we used to say that either you have to paint the name or you affix the name, say, for example, in the form of a metal plate being nailed onto the exterior. Now, we are saying that as long as it is so positioned that it may be easily seen by a visitor to the office, then it will do. Say, for example, just now I said that perhaps you have a glass door, and then you have a plate showing the name of the company behind the counter, and that will satisfy the requirement. So this is more facilitating than requiring it to be painted or affixed. So we are talking about 3 different places. We are talking about the registered office, business venues, and they have to be easily seen by visitor. Ms. Zhang. Thank you, Mr. Chairman. Every business venue and the registered office, I think the Chinese version has to be made clearer. Well, we have been running companies for a long time, but as it stands, it appears that it's a bit confusing. I'm referring to the Chinese version. Perhaps it's legal language, and so it has to be so. Perhaps the councils can advise me. Well, this is already rather well written when compared to others. And then I think you say that you need to show the company name in all the communication documents and transaction instruments. What about emails? You don't actually have a physical copy, and so you can't show your logo. Thank you, member, for your question. If I may elaborate on the details, well, the CO provides that for communication documents and transaction instruments, there is a requirement to state a company's registered name. There is such a requirement in the existing CO, and in the new CO, we have reenacted the same requirement. Of course, electronic communication is getting more and more popular, so we're saying that the requirement applies to the electronic communication documents as well. We are making the same requirement. In the past, for official commercial correspondence, we made the same requirement. And now if you resort to the electronic means, you also have to state the company's registered name. But of course, in the past, you might have something handwritten, and it wasn't so formal, so it would not be bound by the requirement. So I don't see any change at all. In the future, there may be a dispute, and if it is found that certain correspondence or certain internal correspondence do not actually state the company's name, I want to know whether such documents will be rendered invalid. And they cannot be adopted as evidence in relation to the incident involved. Mr. Yu, well, for the existing CO, it says that the requirement is about the external communication documents. For internal communication documents among staff members, I don't think it is being covered. So we are talking about documents sent out on behalf of the company. And for those electronic documents on behalf of the company, again, they will be bound by this provision, but internal communication will not be caught. What about if I'm talking about a letter? It isn't a company document, but then the email address is the email address of the company. So if the email address is the company's registered name, I don't quite understand. Well, I can make it simple. Say, for example, there is this employee who would like to void an invoice or to cancel a small order, a small volume order. So maybe he will issue an email from his home. So when he issues the email from his home, he may be using his personal email address. It doesn't carry any company name. He simply says that I'm N. We are no longer interested in placing an order, say for example. Or maybe somebody can use the email address from his home, and the email address carries the name of company ABC. Would it be allowed? So I'm afraid that there may be disputes. Maybe one day somebody will say that because when you inform me of the cancellation of the order, you haven't stated your company's registered name. So I won't say that it is acceptable. Yes, Ms. McKenna?
I think if you're talking about the validity of the communication, that there is a provision in the main ordinance, section 661 of the main ordinance, which provides for the civil consequences for failure to disclose the company name in any kind of communication, or the communications that are set out in that particular section, which is a bill of exchange, promissory note, endorsement, cheque, order for money or goods in which the company's name is not mentioned in the manner required by the regulations. Then the officer who signed that or authorised it to be signed would be personally liable. So that is a civil consequence. That person would be personally liable. The point of the company name is to ensure that people are aware that this is an organisation with limited liability and that they know who they're dealing with. So it's a civil consequence. There's also a criminal consequence for breach. But the issue of between third parties, if it's a company document, there's no question of invalidity. It will be the civil consequences of the breach that will kick in here.
Is it clear? Maybe you can ponder upon it later on. We can move down the list of members. Mr. James Toh, if I may follow up on Dr. Zhang's question. It talks about communication documents and transaction instruments of the company. It seems that this is different from what we used to think about, like having transactions and the transaction talks about contracts, deeds, bills of exchanges, invoices, receipts. It seems that the Chinese and the English renditions are not quite equivalent. Communication documents include business letters. So when we want to place an order, would that be regarded as a business letter? If you want to place an order, then it's an order. So business letters, if I want to sell something or if I want to place an order, it should be a business letter. Sometimes you will place an email. Even if you have goods of a value of hundreds of thousands of dollars, it may only be in the form of an email. Mr. Yu, do you have any answer to this question? Well, as far as communication documents and transaction instruments are concerned, we want to reenact the definitions of the existing CO. And in fact, there are indeed specific provisions to provide for the definitions. you can go to Annex B of the legislative brief, and you find the interpretation section. Well, there are different kinds of documents. It will be difficult to be comprehensive or exhaustive. We intend to cover all the formal documents. As to the order that you want to place, I suppose it should be included. Well, Mr. Chairman, I don't think it is a very serious matter, but then the provisions are supposed to be complied with, so you need to have clarity. Now, communication document, it refers to business letter. Business letter. But what about transaction instrument? It talks about contracts. For communication document, we talk about business letters. So, will business letters cover transaction instruments? So I think you need to sort this out. Mr. Yu, at the next meeting, or prior to the next meeting, can you not write a paper and address the point about members' doubts about the equivalence between the Chinese version and the English version? So please clarify the meaning of such terms. Would that solve your problem, James Law? And please also tell us whether it is a definition at common law and whether you have overseas reference. Mr. Chairman, as you said that we need to display the company name. Well, there are 2 points here. Well, a company, an import-export company. Generally speaking, no visitors will come. They always do it on the internet, serving both buyers and sellers. So maybe the registered office is the address of a law firm or accountant's firm. So it is not actually open to the public. So here, when you talk about open to the public, would it be like in this case, that is, if somebody did come up to the office in the past to attend a meeting, would that be open to the public? Or what about people just walk in to buy an item or to have a beauty service? So if people only come up to the office to attend a meeting by appointment, would it still be regarded as open to the public? What worries me is that for some companies, maybe the company is actually in Kwai-chung, so they would like to have a downtown office. And if you want to make an appointment to have a board meeting, and then they may sign a contract to the tune of hundreds of millions of dollars, would that be regarded as a business venue? But then it is a trading company, so they sign a contract. So it isn't the same as touting or soliciting customers by showing you the goods. So I want to know whether this will be counted. Sometimes a company may not want to be conspicuous as to whether there is the presence of an office, and sometimes they may just be very vague in relation to the display of the name.
去嗰度傾嘅喎，咁係咪要釘牌又唔使釘牌咧？咁
係姚生或者麥女士，
即係掛個牌啊 ，sorry， 唔係釘牌。OK，display。
They will just affix the sign. Yeah.
盧議員講個問
I can respond to that. Mr. To, we have actually made an amendment relative to the existing law. So for all business venues, even if you don't hold any meeting, but as long as they operate their business, the import-export business, then they need to display the business name outside the venue. This is the current requirement. Now, we are aware the business community have expressed that they have no visitors in some venues, and they feel it's not necessary or they don't want to have visitors. So to deal with that, we have made an amendment here that is, it has to be open, venues open to the public. They need to display their business name. So Mr. To's specific question is that even if they held 1 or 2 meetings, I think we have to look at it as a whole. If they had a very exceptional occasion where one visitor visited, then that might not be necessary to have a business name. But if it's open to visitors, then visitors who visit that venue, they have to know, they have to be aware of the business name, and the business name has to be displayed. But if you say they are regular visitors, then they meet our criteria. They have to display the business name. The chairman, the wording is open to the public. That means any member of the public who walk in for retail or who seek a service, then you need to display the business name. But if there are business meetings held, convened by invitation only, well, it's not just limited to purchase and sale of goods and services. So import-export business might have visitors for business negotiations. They do not have to be only by invitation. They would have regular meetings, and we feel that they should comply with our regulations. Well, lastly, we have some old commercial buildings. They have a, let's say have a wooden door, and in 3.2, disclosure of company name, 3(2), they said it has to be easily seen by any visitor. So assuming they've opened the wooden door, then it's visible. But it's not a transparent glass door. The display is not on the wooden door. You can't see it unless you open the wooden door. Does that comply with 3(2) then? Mr. Yu? If there's a wooden door, they have to open the wooden door before you can see the display. But the door is closed, and just from the exterior you can't detect the business name. Mr. Yu?
I think each case there is going to be a huge number of permutations as to how this is going to play out in actual practice, and each case we have to look at reasonably. And I think in Mr. To's example, if there was a company that was operating at a particular place, and any time somebody went to that company they couldn't gain access and the door was constantly closed, I think we would say they're not complying. And that would be a visitor has gone to that place and they cannot easily see the name. If they go and they are going for a legitimate reason, they are a visitor to that place, not just a passerby. I think what we're saying is it's not for just a passerby who has to see the name. We're saying it has to be a genuine visitor to that premises, so that is going to conduct business with that company or has a legitimate interest in knowing if that company is operating there. So if they go and they try to get access and the door is open and they see the name, then it's complied with. But I think it will be, and the registrar will act on complaint in these cases. So if we get a complaint that somebody has continually tried to access an address which is given as a registered office and they can't see the name is there, then they have not complied. So it will be a matter of fact in each case.
Okay. 下一位梁繼昌議員。
Next, Mr. Leung Kai-chang. I have 3 questions. In Legal Notice 7, words and expressions, in company names, I'd like to ask about the schedule Is that an all-exhaustive list? Mr. Yu? Let me respond in detail. Under the Company Ordinance, there are some restrictions. In the principal legislation, we have reiterated the current requirements. That is, company names and other names cannot be the same. It cannot be an illegal name. What do we mean by illegal name? Let's say under the banking ordinance, the term bank has some restrictions. So under the Companies Ordinance, anything that would constitute a breach cannot be used as a name. So indirectly, they cannot use the term bank, and the company name cannot mislead people into believing that it is government related. It cannot be repulsive. It cannot be against public interest. So there are certain restrictions. Besides these restrictions, there are other requirements under the annex on prohibited words. So even though there are restrictions, we feel certain words, if they are to be used, have to be approved by the registrar. So this is not the only restriction. There are other restrictions that I mentioned. Well, in your table, you've included the Tourism Promotion Bureau. So if I call my company a certain tour promotion company, does it have to seek approval from the company registrar? Let's say if I call a company Legal Service Promotion Board, so you have the Tourism Bureau, it might give people the impression that it's related to the Tourism Bureau. Well, if you call a company a certain promotion bureau, it does not require the registrar's permission under the annex requirements. But as you said, it might give people the wrong impression that it's related to the government, and therefore the company registrar can deny that application. Okay, my second question is about LN10, Director's Report. You've introduced a new definition called equity-linked agreements. Under this definition, there are three sections. A is a general definition. B includes 1, 2, 3, 4 options, agreements for issuer of securities, share option schemes. So could you explain, in B, there are some examples. It's not an exhaustive list as well. Is my understanding correct? It includes the following conditions, and C does not include certain conditions. It's not exhaustive. That means some agreements might not be in B, but it could be covered by this definition. Because in the future there might be some new products, and we have, first of all, in A, described what is included, and then in B and C, we have some examples of what we intend to be included and what we intend not to be included. The purpose is stated in A. My third question is about LN11, Summary Financial Reports. This regulation seeks to regulate non-listed companies where they issue summary financial reports. They have to comply with this regulation. So my understanding is that these unlisted companies, they don't have any legal obligation to issue summary financial reports. That means they can issue a full report to shareholders. Is that understanding correct? That is correct, Chairman. It's just voluntary. It is not mandatory. That is in the principal legislation. Okay, thank you. Just like to supplement a little. It's not just applicable to non-listed companies. Under the current Companies Ordinance, it's only applicable to listed companies. But this new amendment, it would include listed and non-listed companies who issue summary financial reports. So it's applicable to listed and non-listed. For companies who have not prepared summary financial reports, whether listed or not. Chairman, I'd like to follow up on Ms. Zhang Laiwan's question. She said that business letters, does that include email? If not, if the company's name is not indicated, will that affect legal liability? So is the response included in section 661? It says that if you sign checks or promissory notes, endorsements, bill of exchange, if you don't include the company name there, if you don't comply with section 659, it will affect the check and promissory notes legal status. So have we responded to Ms. Chang's question? If there's a business letter, a communication that did not display the company name, there will not be any civil or legal liability. Is that correct, Mr. Yu?
This letter is not included in the issues where personal liability is given. That would not affect the liability of the company. I think that would just be a breach of the ordinance.
Yeah. So there won't be any civil consequences in terms of business letters or emails who have failed to comply with the requirement to disclose the name of the company.
No, the civil liability is dealt with.
Yeah, that's my understanding
yes.
as well. 我第二個問題，我睇緊嗰個
My second question, in disclosure of company name and liability status, referring back to section 3, subsection 4, it refers to accounting transactions. What's the definition of accounting transaction? Mr. Yu? Chairman, accounting transaction already has a definition in the principal legislation. Mrs. Ho? In section 2 of the principal legislation, in the interpretations, they refer to accounting transactions. In section 5, is there a definition for manager? There should be a definition. There should be yes. And that refers to managers appointed by the courts. Is it correct? Yes, Chairman. It refers to an exemption, liquidator, and manager. The principal legislation definition refers to management, but this one is referring to a liquidator. So is that not clear? Because the courts will appoint liquidators, and the definition of receivers, liquidators, they will also use the term manager. The orders will refer to receivers and managers. So this requirement, are you referring to management or the courts, receivers and managers?
Cover the situation where a liquidator takes over the business of a company, and of course that is the liquidator or manager's function in a lot of cases, and it's to avoid them having to display the company name, all of these company names outside their own premises. So it's to alleviate the obligations of the receivers or managers that are appointed by the court to undertake or to take over the business
Okay,
of the
so
company.
you may want to consider making that clear in the regulation.
I think the Section 2 definition makes it clear that that's excluded from the definition of manager in the ordinance. That's specifically stated in the Section 2 definition, that manager excludes a receiver or manager of the company's property and a special manager of the estate appointed under companies winding up provisions.
Okay.
So if you think it's necessary, we can look at it. But
Well, why do you think about it?
Yes,
Thank you.
certainly. Thank you.
The last question is in relation to Section 6 of the same regulation. I see the abbreviation for company is co, which we are all familiar with, but koi is not something that is often seen used in Hong Kong, at least not in the common law jurisdiction. One doesn't see the abbreviation COY used. And COY actually means other things too. Having checked on the internet quickly just now. So I'm not sure whether you would want to use COY.
This is existing law. This is currently Section
Is it?
94, yes, of the CAP 32. But that is certainly something. If you feel that it is objectionable, we are just reinstating existing
Again,
law.
something for you to think
We
about.
can think
Thank
about
you.
it. Thank you.
呢個舊條例已經係冇啦。下一位
It's already there in the existing CO. I think there is a lot of business correspondence for a company. If you don't make it clear, I want to follow up on Ms. Zhang's question. If you don't make yourself clear, then many companies in Hong Kong will be caught. Yes, this may very well be civil liability only, but it could have a lot of serious consequences. I always get emails from the government, but it doesn't carry any particular names or logos, so do I have to take it seriously or not? So you have to make it clear as to what is to be covered. Buying and selling of shares, payment of money, etc. Usually, nowadays, companies would transact by way of a email, and it can run up to millions or tens of millions of dollars. I may place an order to buy materials, and yes, when you are walking in the street, you may just place an order over your by using your iPhone. So I want to know whether the email will become invalid if it doesn't carry the company's name. Of course not. Well, we've spent a lot of time to rewrite the company ordinance so as to make it modern. And then in today's business world, we make frequent use of emails. Every day we receive hundreds of emails. So how should I regard emails with the company's names? So perhaps we need to revisit the principal ordinance. So Mr. Yu, please go back and reconsider this matter. You have to make it clear. I don't think we're going to let you off if you just maintain the version as it stands. You need to tell us about the case in Australia and the UK, because I understand that we usually borrow the references from those two places. In the principal ordinance, I think this hasn't been discussed, and I think this is quite contrary to our usual thinking, and we need to be up to date. We can't just take it lightly. So I don't press for an answer on the spot, so please go back to consider this. And then company name. Again, you need to consider the matter again. There are a few points here. Say, I have many holding companies. Are there any transactions? Not really. Now, if you say that as long as this is not open to the public, it will be fine. But then if a reporter may understand that Mr. Ting-kwong has an office in a certain place, well, the reporter would say that he's a member of the public and he would like to visit your office. I think you have to sort out the legal position. Many law firms and accountants firms are acting as the registered office of many companies. So when someone goes up to a law firm and say that he is interested in investigating into a particular company, like company ABC, we want it to be reasonable, sensible, and workable. Currently, I may go to a Chinese restaurant to have dinner. The restaurant is called Restaurant ABC, but then when I pay for the bill, and when I pay with my credit card, it is called XYZ rather than Restaurant ABC. You have never been enforcing the law. Now you are saying, by way of this regulation, say that since somebody in the name of XYZ is charging me, though when I go into a restaurant, the shop's sign is ABC. It is quite common, and no one is enforcing the law. It seems that you are merely reenacting the existing CO, but I'm afraid the new regulation will affect anybody. You may very well say that it has always been against the law. But then you haven't enforced the law. You have never taken anybody to court. You haven't asked the company register to enforce the law against companies which haven't displayed their name. So you're introducing something new which is not in line with the usual business practice. I think it is very risky. So there may be millions of companies found to be breaching the law. So please go back and prepare a very detailed paper to cover this point. I think it is a point of great interest and concern to members, and you need to handle this. Mr. Leung, I think you need to give them time to consider their reply and come back with a written answer. All right? So, Mr. Yu, you do need to answer the questions. So go back, consider the case. So just jot down the questions. Next, Mr. Paul Chair. Mr. Chairman. Well, I was about to ask the same question as that asked by Mr. Leung. I wasn't on the Bills Committee of the CB during the last term. So please bear with me if I show that I'm not quite familiar with what transpired during the Bills Committee meetings. Now, it seems that in the subsidiary legislation exercise, we are dealing with the details like the registered address, etc. Has there been any mischief so that you need to tighten up the regulations or the requirements? I think the existing CO, probably in section 923, we do have a similar requirement. As Mr. Andrew Leung has said, are we talking about widespread non-compliance? And if there has been widespread non-compliance, has there been any enforcement of the law? And what about the penalties? I want to know why you want to tighten it up across the board. I think we have to understand the background. Do you have any initial reply to enlighten us? Mr. Yu. If I may clarify a point and emphasize a point, we aren't really tightening it up. On the contrary, we're relaxing the rule. Currently, you need to display your company name either by painting it or affixing the name, like in the form of a metal plate. There aren't any exemptions. You need to do it across the board. Now, in fact, we want to introduce flexibilities when it is a very obvious case that you don't open your business venue to the public, then you are exempted. And we also say that you don't actually need to do it outside of the office, as we've been told that it may not be that feasible. There would be operational difficulties to do so outside of the office or place of business. So we're relaxing the rule. That is, it only applies if it is open to the public. So if it is not open to the public, then you don't need to display the name. Currently, the company register acts on complaints in relation to such requirements. And in the past, there were complaints saying that companies did not display the names, so their visitors found it difficult to locate them. And there were indeed prosecution cases. As to the penalties, if I may, in passing, talk about the changes. In the past, if you don't show the name, then there will be a daily fine. But then under the new CO, we have already shot out the daily fine. So there is only a one-off fine instead of a daily fine for a continuing offense. And again, we've aligned the requirements concerning the officers in default. In the past, for the company and the officers in default, when there wasn't compliance with the display of name, well, in the past, only the company would be caught rather than both. We believe that the nature is similar, so we want to align the two requirements. So under the new CO, both the company and the officers in default have to be held liable. But then we have done away with the daily fine. And the penalty is set at level 3 in both cases. Well, probably in the past you were rather sort of relaxed, and then the company's register would only act on complaints. So please give us a written answer. Tell us about the prosecution situation in the past. Yes, a daily fine may sound alarming, but I don't think there was a single case in the past incurring a daily fine. I think in the past the net was cast too wide, and so we have been relaxed in the law enforcement. Now, here, on the face of it, it is a tightening up. I think you have more details. So are you going to be more vigorous in the law enforcement? Are you going to take it more seriously? I think you need to send out the message clearly to the public. For law firms, accountancy firms, and the company services providers, I think they are faced with a new situation. On the face of it, it may be relaxation, but to me, I think it's a tightening up. Well, I think for the Legislative Council, what we want to see happening is that when a provision is contained in the law, then we want it to be enforced. If you don't enforce the law, there's no point in introducing any provisions, and therefore clarity would be important. Now we come to the second round of questions. Dr. Chiang. Thank you, Mr. Chairman. But then other members have already asked the questions that I had in mind. Well, members have already asked many detailed questions. I want to consult the views of members in relation to the following points. For the 5 pieces of subsidiary legislation before us, members, do you think we need to invite individuals and related deputations to air their views before us? That is, do we need a public hearing? Mr. Leung, I don't think so. First of all, we have only got limited time. We see that we are asking the administration to come back with certain answers. The work is rather technical in nature, so probably a public hearing is not necessary.
As a matter of fact, by 15th of March, we need to report to the House Committee. It's rather urgent, and some colleagues might not even be in Hong Kong in the first couple of weeks of March. So we need to exercise tight control on convening of meetings, and if we are to report back to the House Committee. I'd like to understand the 5 areas. Do you include the controversial items? No. Just the first 5 items. If we don't have any other views, then we won't consider inviting the public or relevant deputations to voice their views. In that case, we still have some time. We can go into clause by clause. Who will be conducting that part? Well, I'd like, if you are to do clause by clause, can you do the non-controversial parts? Yes, I agree. For the more controversial items, where the administration has not responded in detail, we can postpone that till we hear your response. So we'll set that aside, and we can handle the less controversial items. Okay? Okay, Chairman. Just now, members asked about company words and expressions and business letters. That's in the second part. We can set that aside and deal with that later. So if we are to do clause by clause, I suggest the first, words and expressions, in Annex A of the Legislative Council brief. So we have, that's relatively easier. There's only two parts. The commencement date. This will come into operation on the day on which Section 101 of the Companies Ordinance comes into operation. It will take effect simultaneously. No problem, let's continue. The second, it's technical. The specification of words and expressions for purposes of sections 100 bracket 2 bracket B. These are referred to in the schedule, and there are some 16 words and expressions there. And any problem? Let's continue. And that concludes that part. Companies, words, and expressions in company names order. Next, I'd like to ask, what is Kai-Fong? Okay, Kai-Fong. Then we move on to Annex B. Are we going to set that aside? Yes, we're going to set that aside. So we'll jump over this one and move on to Annex C. Annex C is the accounting standards, prescribed body regulation. There are only two pieces there, as we said. The law requires companies to prepare accounting reports as prescribed by a designated body. In Hong Kong, that would be the Hong Kong Certified Public Accountants. So the Certified Public Accountants are the prescribed body in Section 2. Any questions? So, companies' accounting standards prescribed body regulation is very simple, clear, straightforward, not controversial. Okay, then we can move on to Annex D, Companies Director Reports Regulation. Thank you, Chairman. The Companies Director's Report Regulation, we have some 9 pieces. First is commencement, as with the previous examples. They take effect on the day at which Section 452 bracket 3 comes into operation. We also have some interpretation of terms. We can come back and revisit this when we get to the relevant parts. Section 3 to 9 are dealing with report contents. Section 3 refers to directors' interests. It's an existing legislation. The director and the company make an arrangement where if a director receives interest through purchase of shares, they have to list that in the report. Regarding transfer of shares, it's the same as the existing ordinance, but we have made a change here where we do not have a disclosure requirement for debentures. We do not require disclosure of acquisition of debentures. Any questions? James Toe? Well, we're just copying the UK example, but why isn't there any interest? Well, why shareholders or an outsider would not consider that being a matter of company interest? Let's say if it's a listed company. I don't quite understand your question. The response is that we are relaxing disclosure requirements, but debentures, why isn't that a matter of interest? Why isn't that something that the public should be aware of? Mr. Yu, aside from your response that you're following the UK example, yes, Mrs. Ho can supplement after my response. Director report is a report to shareholders. The regulation on shares are more important because it deals with any change in the transfer of shares. But for debentures, a lot of companies issued debentures to raise capital, but debentures don't have an impact on the shares structure. So that disclosure might not be so important to shareholders. Well, that's not the case. It's debt. I think it's more related to liability. You're talking about the status of the company, Mrs. Ho. So is it something that is available in the audit report? Well, if it's an important issue, it should be. I'm not arguing about that. It should be made available. But can we receive this information through this channel only, or are there other channels? Mrs. Ho? Relaxing the debenture disclosure requirement. We had actually consulted the Company Ordinance Reform Committee, and their opinion was that debentures is just one way of raising capital. It does not need to be separately disclosed. That was the reason, the rationale. So the company has borrowed money, whether it issues a debenture or not. Are there any other means of acquiring this information? Is there any means of being aware that the company has raised capital through debenture? Yes, you can see that in its accounts, in its annual audit report. Yes. In the balance sheet, it is disclosed. Well, if the company has issued debenture to its directors, that has to be reported. That's what I want to ask. Any transaction between directors has to be disclosed. Well, directors borrowing money and whether there's conflict of interest, we deal with that in the principal legislation. It has to be disclosed. I'm aware of the principal legislation. It is very stringent. So certain actions need to be disclosed immediately, but in the director's report, it's an annual exercise. Why can't they summarize that here? Well, we have a separate legislation regarding director interest disclosure. It's still in the drafting process, and it will require dealings and borrowings between directors and the company. Mr. To, in the last term, were you a member of the bill? Yes. Oh, to give you an example, if you relax the debenture disclosure, I need to know what information is missing. If it's disclosed in the accounting report, and if you issue, in the director report you say you've issued debentures to so and so at a certain time, that information would be more detailed than other borrowings, and you can have it listed separately and you can break it down into different parts, but you wouldn't be aware of certain information. So to understand a company's inner workings, the director report is disclosing information to shareholders and other stakeholders. This is important. How much money is borrowed, if it's just passing from a left hand to a right hand, you're inflating debt. Or if you're borrowing from banks or third parties, that's a very separate issue. Mrs. Ho, could you consider this? I need to clarify. Under the subsidiary legislation, we're referring to directors and their arrangement with the companies. This director will receive shares, and we have now exempted debentures. We are dealing with this arrangement, not debentures already issued. The disclosure is about two different matters. Well, you said in the past this regulation, this subsidiary legislation, the director report, had what kind of debenture did it have to report? All arrangements between the director and the company and subsidiary companies. This director, through this arrangement, if he purchased the company shares or received options, well, you say you relaxed it. That's correct. We don't require debenture disclosure. So directors, if they receive shares, they have to be disclosed. But through arrangements, if they receive debentures, they don't need to disclose that. Why? Isn't that interest? As I said just now, the Company Ordinance Reform Committee recommendation. No, listen, I'll give you an example, and perhaps you can reconsider this. Let's say, for example, the company is a AAA credit rated company, and similar debentures by other companies only have a certain carry only a certain coupon interest rate, but when they issue to this director, it's much higher. So through the higher interest, there is a very safe investment. There's a significant interest. Why isn't that an interest, an advantage? It's just that simple.
能夠取得
So, if you can acquire the shares, and if you take that argument further, now when it comes to the shares, you say that under 3(2)(b), just the end of it, it says, for Company A, if there is an arrangement for allow a director to acquire the shares in other body corporate, that is, we aren't even talking about subsidiaries, it has to be reported. Say, for example, I work for you, I perform well, or for one reason or other, according to an arrangement, you facilitate my acquisition of the HSBC shares. So it's any other body corporate. So the main point is about the benefits rather than the shares. So if the benefit is about the acquisition of the company's debentures or the acquisition of debentures of another company, then it must be a benefit. You can't say that it's not a benefit, so it has to be included. There's no way that we should allow it to be exempted. Mr. James Cho, I fully understand your question. I also attach a lot of importance to this matter. The Company Law Reform Commission made certain recommendations, and then the government drafted a bill, and it was scrutinized by the Legislative Council. Now we have this subsidiary legislation exercise. So whenever we spot any problem, we need to follow this up. So please go back to consider it. Don't just blame it on a recommendation from the Company Law Reform Commission. Yes, please give us the rationale and have the arguments being laid before us. Perhaps we should be facilitated in understanding this concern. Well, we have raised this point. I think we need a paper from them. Yes, they have to set out the rationale, and perhaps they should tell us about the alternative channels through which we can understand the background. Mr. Chairman, well, perhaps it's from the UK Company Law or Companies Act, or it's a recommendation from the Company Law Reform Commission. I think we want to know about the rationale, rather just the fact that it has been relaxed. Mr. Chairman, we will certainly go back to follow this up, but I've already given you the reason. Yes, indeed, but then Mr. James Cho doesn't quite accept your reason. No, I don't accept it that they relax it and so we have to follow suit. It is not convincing. Well, I think his point has been made loud and clear. Let's continue. We have to end by 10 o'clock. Andrew, a follow-up. Yes, I hope that the administration will cover this point. We are talking about arrangements rather than the actual acquisition of interests or debentures, because they have to be declared annually. I hope the administration can also cover the following point: listed companies and unlisted companies. I want to know whether the listed companies have to abide by certain disclosure requirements. Would this be applicable to unlisted companies only? So please also answer such points as well. We're supposed to hand over the venue to another meeting by 10:15. So let's take a look of the legislative timetable. The expiry of the scrutiny period falls on the 27th of March. After it has been extended, we'll try our best to cover as much as possible. So please remind us if indeed a member thinks that this cannot be endorsed, then it will be shut down. I want to know about the final deadline. Yes, allow me to continue. You are too impatient. So we need to report to the House Committee on the 15th of March, and the deadline for giving notice of amendment to the subsidiary legislation will be 5 clear days afterwards, so the 20th of March. The 20th of March. So the deadline for moving amendments, or rather giving notice of moving amendments, 20th of March. As to the date of the next meeting, can I take up the matter with the Secretariat? I think, tentatively speaking, we want it to be held on the 27th of February between 8:30 and 10:30 a.m. We haven't got anything under AOB. Thank you. So we need to be conscious of the tight schedule. So please go back to consider the points made.